Last weekend, I was stopped by a border agent and detained at a border crossing. The agent asked me my name and asked me other questions. And then he asked me for my license. I responded, I am an attorney and I will comply. After he looked at my license, he eventually released me. Now, let's consider that agent, after having determined that I was a United States citizen and that I had not committed a crime, held me for an additional 2 hours. Well, that would be a lawsuit against a federal agent. And it used to be when plaintiffs could sue a federal agent under Bivens. But the United States Supreme Court has abolished that. Now, the same actions by this border agent, if he were a local police officer, would trigger a violation of 42 U.S.C. 1983. And I am going to use this experience to demonstrate to the pro se how to overcome a motion to dismiss and how to defeat the defendant's defense of qualified immunity. So let's get started. Surviving the motion to dismiss and beating qualified immunity. The key to surviving defendant's motion to dismiss and defeating qualified immunity is pleading plausible claims. The key to pleading plausible claims is pleading plausible facts. So let's review the Fourth Amendment. The Constitution, through the Fourth Amendment, protects people from unreasonable searches and seizures by the government. The Fourth Amendment, however, is not a guarantee against all searches and seizures, but only those that are deemed unreasonable under the law. Now, let's review qualified immunity. Qualified immunity is an affirmative defense raised by government officials to block civil liability. To overcome this defense and defeat an official's motion for immunity, a plaintiff must satisfy a two-pronged test, proving that the official violated a constitutional right and that the right was clearly established at the time of the unlawful conduct. Before qualified immunity is even evaluated, a plaintiff suing a state actor must establish a prima facie element claim under Section 1983. And they are: 1, the plaintiff must demonstrate state action in the complaint, that the defendant was acting under color of law, custom, or usage. 2, deprivation. The plaintiff's complaint must demonstrate that they were deprived of a constitutional right. The defendant's intentional or reckless actions deprive the plaintiff of a specific statutory or constitutional right. Now, the two-pronged qualified immunity test. What does it look like? Part 1, the constitutional violation. Whether the facts alleged show that the officer's conduct violated a constitutional right. Here we go again. Facts. Listen, the success of a 42 U.S.C. 1983 complaint hinges on facts. And you'll see later what I mean. And the second part of that test, clearly established law. Whether, now listen to this, whether the right was clearly established, meaning existing precedent, binding case law in that jurisdiction, preferably, placed the statutory or constitutional question beyond debate, giving the official fair warning that their specific conduct was unlawful. Again, hang on to clearly established because we're going to look at this again. So I want to share with you my strategy in constructing a complaint, a 42 U.S.C. 1983 complaint, to overcome the defendant's motion to dismiss and to defeat the officer's defense of qualified immunity. Step one, here we go again. Those facts. Vet your facts. Pro se litigants often lose 1983 cases at the Rule 12b-6 or motion to dismiss stage because they plead conclusions instead of plausible facts. Listen, the court doesn't want to know how you feel. The court doesn't want to know what you think about the defendant. The court wants to hear the facts and nothing but the facts. Stay away from embellishing. Control your emotions, okay? The material facts, let's look at them. I was stopped and detained by Officer Jones. I complied, provided my ID, and answered basic questions. Officer Jones verified my identity and determined I had not committed a crime. Nevertheless, Officer Jones kept me for 2 full hours after determining I committed no crime. Officer Jones did not state why he stopped me. Step 2, the prima facie elements. Pro se must know the prima facie elements for 42 U.S.C. 1983 in order to determine whether the case has facts to support the elements of the claim. So look to the facts that you vetted. Hopefully you vetted them objectively, no cherry picking, okay? State action elements, acting under color of law, custom, or usage. That's one of the elements that the plaintiff is required to establish. And how does the plaintiff establish that? Officer Jones, fully dressed in his uniform, stopped me. Let's look at more. He asked me, "Where are you going?" Still in the full operation of color of law. Explaining I was lost, I showed him my phone. He then asked to see my license. Nevertheless, after learning I had not committed a crime, he held me for an additional 2 hours before releasing me. So let's look at these elements for deprivation of a statutory or constitutional right, namely, in this case, Fourth Amendment. Now, considering all the other facts that have been established, nevertheless, after learning I had not committed a crime, he held me for an additional 2 hours before releasing me. Definitely, I was deprived of my right to not be unlawfully seized. Now, the third strategy, step 3, now, pro se, you're going to merge the claims and the cause of action. Pro se must write the claims, be specific. The causes of action must contain language that demonstrate the prima facie elements are met, supported by facts. So let's quickly review conclusory versus factual pleadings. Officer Jones violated my Fourth Amendment rights versus Officer Jones held me for 2 hours despite he checked my license and learned I had not committed a crime. The first one is conclusory. A conclusory statement is one that is not supported with facts. Whereas in the second statement, which is more specific, you see how it is supported with facts. You see the difference? Now I'm going to demonstrate how you merge the facts and the claims. Now, what you see here represents a complaint. If you look at 6-0, that is the last claim. Now, remember, everything above 60 would include the preliminary information, such as jurisdiction and venue, the parties, so on and so forth. And then you state the claims. So let's assume that the allegations or items 25 through 60 are my actual allegations against the defendants. And everything above that is the preliminary stuff. Can you see that? Okay. And notice that this is the federal cause of action. You may have more than one federal cause of action, but for the purposes of this video, we're going to look at the Fourth Amendment. Notice that after allegation 60, you have allegation 61, allegation 62, allegation 63, allegation 64, allegation 65. And I want to show you something here. So we have the last allegation under claims is 60. Federal cause of action, Fourth Amendment violation under 42 U.S.C. 1983 against Police Department Chief Smith and Officer Jones, because I'm suing the municipality. Okay? Notice, here's allegation 61. Plaintiff realleges paragraphs 1 through 60 as if specifically pled herein. But notice 62, it starts with what? the language of the Fourth Amendment. Pursuant to the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against reasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Listen, it's not like the court don't know the Fourth Amendment. It does. But the plaintiff is still required to cite that. Next, look at 63. Now watch this. As more specifically alleged in paragraphs 50 through 60, Officer Jones violated plaintiff's right under the Fourth Amendment to be secure in her person when, after he checked her license and learned that she had not committed any crime, detained her for an additional 2 hours. You see how in 62 and 63 you are merging the elements and the facts to support the elements or show that those elements have been met. Are you seeing it? And you also notice that I stated as more specifically alleged in paragraphs 50 through 60, I'm referring to the actions of Officer Jones violated plaintiff's rights under the Fourth Amendment. Why am I specifically in this paragraph 63 honing in on Officer Jones and only the allegations 50 through 60? Because one, it avoids the shotgun pleading. I'm saying to the court, even though I am realleging paragraphs 1 through 60 as if specifically pled herein, in this paragraph 63, I'm saying, court, these specific allegations 50 through 60 relate to Officer Jones and not Chief Smith. Now, this is my style. Other attorneys may do it differently, but this is my style. I want to make that clear, okay? So let's look at the next allegation. 64, I did the same thing here. As more specifically alleged in paragraphs 25 through 49, defendant police department and Chief Smith culturally winked at officers' misconduct, including Officer Jones's, and the department failed to train on policies concerning police misconduct. So let's look at allegation 65, and this is critical. You must state that the municipality's policies or customs were the moving force behind the violation. Language like this would be appropriate. See, acts, omissions, policies, and customs of defendant city police department and Officer Jones, and we need to add Chief Smith, constituted deliberate indifference to the constitutional rights of the plaintiff, directly and approximately causing the deprivation of her right described herein. Now, does it make sense? Listen, pro se, plaintiff, it needs to flow. When the court or their clerks read your complaint, if they have to guess what you're saying and if they have to go back and forth to determine where to find this, that, or another, you got a problem. Make it plain, make it clear, and organize it, okay? Because the last thing you want to do is frustrate the court. Evaluating objectionable
reasonableness. The Fourth Amendment reasonableness inquiry is whether the officer's actions are objectively reasonable in light of the facts. Here we go again, facts. In light of the facts and circumstances confronting them without regard to their underlying intent or motivation. The reasonableness of a particular use of force, for example, must be judged from the perspective of a reasonable officer on the scene, and this calculus must embody an allowance for the fact that police officers are often forced to make split second decisions about the amount of force necessary in a particular situation, page 490 U.S. 396 to 397. And this is a United States Supreme Court case I'm citing for the purposes of demonstrating objective reasonableness. And even though my case is a Fourth Amendment violation, the principle and the process are the same. In other words, in 42 USC 1983 claims against police officers. So let's talk about citing case law for a minute here. Generally, in federal litigation, you want to cite case law from the circuit where the case is filed. Now, that does not mean you cannot cite a case from another circuit, but it should be relevant and necessary. In federal court, in federal litigation, we cite higher court cases all the time, such as Graham versus Connor, because they are an appeal of a lower court case. For example, Graham versus Connor addresses the reasonable objectiveness standard concerning a police officer's actions. And that standard can be applied to what circuit or jurisdiction the case is filed in. In fact, I've seen some practitioners use these Supreme Court cases in non federal cases. I guess you could say these Supreme Court cases become the precedent, the standard, so to speak. Now, on the matter of the Supreme Court having functionally abolished the plaintiff's lawsuit against a border agent, see Egbert versus Boley, 596 United States Supreme Court, case 482, 2022. And the question for the court was, does a plaintiff have a right to sue federal officers for First Amendment retaliation claims or for allegedly violating the individual's Fourth Amendment rights while engaging in immigration-related functions? And the court answered no. A plaintiff does not have a right to sue Border Patrol officers engaged in immigration-related functions for First Amendment retaliation claims or for alleged excessive force. Although Bivens permits suits against federal officials for excessive force under the Fourth Amendment, its application to Border Patrol officers raises national security concerns. And this was penned by Justice Thomas, and three other justices concurred with him. However, interestingly, Justice Sonia Sotomayor concurred in the judgment as to the First Amendment claim, but dissented as to the Fourth Amendment claim. She argued that Boley's Fourth Amendment claim was squarely within the scope of Bivens, and only his First Amendment claim was in a new context. So, folks, here we are. Hey, everybody, I trust that this video has been helpful to you. I am Advocate Lucinda, your empowerment lawyer. Until next time, take care.